Good morning, ladies and gentlemen, and welcome to the unyer webinar of the Healthcare and Life Science Group. My name is Christoph von Burgsdorf. I am a partner for commercial and corporate law at Luther Law Firm in Hamburg, and I am coordinating the Healthcare and Life Science Group of unyer. Today I have the pleasure to guide you through our webinar. So in the next 60 minutes, we will navigate you through different aspects of how to resolve disputes in the healthcare and life science industry. In case you have any questions to the speakers, please kindly write them in the chat. We will try our best to answer them at the end of the webinar. We have 4 topics on our agenda, and we will start with a contribution by Ermanno Vaglio, partner of Pirola in Milan, Italy. His topic is disputes in Italian and European pharmaceutical markets. Ermanno will delve into essential pre-submission factors like sharing documents with competitors, obligations, and sanctions. Additionally, he will explore insights on claims in administrative courts and analyze alternative dispute resolution, focusing on the anti-corruption authorities' involvement. Ermanno Vaglio is in charge of the Administrative and Life Sciences Department at Pirola Law Firm in Milan, Italy, with an experience of more than 30 years in these fields. He assists local and foreign companies on both contentious and non-contentious matters, with a specific focus on health legislation and also regulatory compliance issues. So, Ermanno, the floor is yours.
Thank you, Christoph. Good morning, everyone. So I have the pleasure to start this webinar, giving you an overview, a quick overview in 10-15 minutes about the rules and regulations governing supply and service agreements with Italian public authorities. So the main source of this matter is the EU directive of 2014, which gives the general principle on public procurement, which are equivalent all over Europe. In Italy, this directive was implemented by the Code of Public Procurement, by the legislative decree of 2023, number 36, which provides for the way to select operators to grant the award of supply and service agreement. In general, we can say that there are direct award of services and supply if the value of the contract is below 140,000 euro, and a public tender to select the operator when the contract has a value over this threshold. Any foreign company can participate to this kind of tenders, even though I should say that in some cases the Italian portal of the public administrations not always fit for all the details needed by foreign companies, but in any case are complications and problems that can be solved so that any foreign company can participate to these tenders. The common principle of these rules and regulations are that public administration pursue the result of awarding the contract and its execution with the best possible quality-price ratio in compliance with all the principle of legality, transparency, and competition. The contracted authorities shall treat economic operators equally and without discrimination, and shall act in a transparent and proportionate manner. An important thing to consider is that rules of the tender of the procedure, including the contract, are considered lex specialis. This means that apart from the case of direct award, all the rules of the tender as well as the contract are not negotiable. So it means that in the offer you propose an amendment or any modification to the rules of the tender or to the contract, the offer can be excluded. So, as we say in the next slide, the roles, there are various subjects, various subjects involved in the tender procedure, and these are the responsible for the procedure, the judging commission composed by technical experts in healthcare issue, and the anti-corruption authority, which has a supervisory power relating to public procurement and also a sanctioning power. Let's say, for example, that an operator cannot give adequate evidence on what declared in the offer, or there is a case of an attempt to influence the outcome of the procedure. This can imply for the operator to be listed in a register held by the anti-corruption authority, which is accessible to any public administration, and what indicated in this register can be affect the reliability of the operator, and the same operator can be excluded. In some more serious cases, the anti-corruption authority can also suspend the right to participate to the tenders up to 1 year. So the next slide, there is also a topic that I think is very useful to consider when you participate to a tender, which is the topic related to the disclosure of documents. So the Code of Public Procurement in general states that all the documents of the procedures, including the offers or all the operators participating to the tender, shall be available for the participant to the tender. Of course, there is an exception, because in case of documents and information containing technical or commercial secrets, for example, due to specific innovation or industrial property rights, in this case, the access to the documents can be limited. But you have to consider that the access to this document is always allowed if they are necessary for the competitor to raise a claim to protect its interests related to the tender procedure. So this matter lead to many controversies before the courts, and so as we can see in the next slide, the Supreme Administrative Court, in some cases, I quoted a recent one in June 2025, the Supreme Court specified that if you want to limit the access to your documents, you have to specifically indicate which specific document you consider covered by privacy, and so you have to demonstrate that this is subject to economic exploitation by a competitor, capable of guaranteeing a competitive advantage to the operator in the relevant market. So if you demonstrate this, you can limit the access to your documents. Otherwise, the principle of transparency in public tenders prevails. So in the next slide, just some key points of disputes relating to this procedure. If there is a dispute relating to the outcome of the tender procedure, one of the initiative of each operator could be the request of self-review. We call it istanza di autotutela. It's a very common instrument because it is at no cost and with no time limitation. And with this request, it is always possible to submit to the public entities a request to self-review and hence annul or modify an unlawful deed previously issued. Another initiative, extrajudicial initiative, is to raise a request before to ANAC, so the Anti-Corruption Authority. So if there is a dispute, this authority can release an opinion to solve this issue. And if the party agree to consider this opinion compulsory, this is binding for the party who submit the issue to the Anti-Corruption Authority. However, even though it's not compulsory, for sure the opinion of the authority is a material element in a possible subsequent claim before an administrative court. So as we see in the next slide, the system of courts here in Italy provides that there are 1 or 2 administrative courts in each region. Here in Italy, we have 21 regions and 1 Supreme Court of Appeal located in Rome. So the scope of the claims usually is to raise a claim that you have to do it within 30 days after the publishing of the deed you want to challenge. And you can ask the court to annul a call for bid. For example, if you refer to clauses of the call for bid which can imply an immediate damage to the operator, or you can ask for the annulment of the deed of exclusion from the tender, as well as against an award to a competitor. So the possible outcome of this claim is, as said, the annulment of these deeds, with a consequent ranking scroller to obtain the award of the tender, but you can also ask for a compensation for damages if you demonstrate them. A specific competence of the administrative court of first instance in Rome is the one when the operator wants to challenge general deeds. For example, ministerial decrees which provide for rules, general rules or regulations governing a certain topic. If we speak about healthcare field, probably you have heard about the payback cases. And consider that now there are more than 2,000 cases pending before the administrative court of Rome against the payback mechanism, which provides that if the public expenditure on medical devices exceeds a specific limit, a portion thereof shall be reimbursed by the supplying companies, each on a pro quota basis. We are speaking about 2 billion euros of national level, at national level, retroactively requested for the periods 2015-2018. We must say that after these claims, the government has recently reduced the amount requested from all the regions in Italy to the 25% of the total amount initially requested. So it means that in a certain way, these cases had a success, even though are not concluded, all of them at least. With reference to the execution of the contract, so the phase after the tender procedure is concluded, is subject to the jurisdiction of ordinary civil courts. So a different judge who decided about the relationship entered into with the contract. As we see in the next slide, always with reference to the execution of the contract, there are alternative dispute resolution, and more in particular, the settlement agreements provided by the Code of Public Procurements that provides the possibility to reach a settlement with the public administration. And specifies that if the value at stake is over 100,000 euro, a preliminary opinion of the state attorney's office is needed. An alternative instrument is the arbitration, and the option is possible only if the call for bid provides for it. So it's not an absolute right for each operator. In any case, if the call for bids provides for it, the successful bidder can refuse to accept the arbitration clause within 20 days after the award. In that case, the clause is not included in the contract. The decision of the arbitration panel can be challenged before the Court of Appeal, which is the civil court. So I think these are just few points relating to the disputes about this field, and I can answer to your question or curiosity at the end of the webinar together with my colleagues.
Yeah, thank you very much, Ermanno, for your contribution. We will now move on and take a look at the Austrian perspective. Barbara Kucher and Dr. Thomas Frath from KWR in Vienna will speak about the protection of trade secrets in Austrian pharma and life sciences litigation, and they will explore available measures for safeguarding confidential information in civil proceedings and examine how the court can protect trade secrets when the burden of proof lies with the plaintiff. Additionally, they will consider the extent of the proof burden in patent infringement cases without detailed knowledge of the manufacturing process, offering practical examples and recommendations for the involved parties. Let me introduce the speakers. Barbara Kucher is the head of IPIT at KWR and a recognized expert in these fields. She specializes in pharmaceutical law, trade secret protection, innovation strategies, and high-stake cross-border litigation in these areas. Dr. Thomas Frath is the head of dispute resolution at KWR. He represents clients in complex disputes in both litigation and arbitration proceedings. In addition, he is the chairman of the managing and senior partner board of our unyer network. Barbara and Thomas, we are looking forward to your contribution.
Thanks, Christoph. Good morning, ladies and gentlemen. And after Ermanno explained to us how trade secrets are protected in public procurement, and the rules in Austria are similar to the rules in Italy, we will have the chance to explain to you how trade secrets are protected in civil proceedings. Before I start with the main topic, I want to raise just one issue. We are talking about litigation, and as you will hear, there is no 100% 100% guarantee that your trade secrets will be protected in litigation proceedings before ordinary courts. So it might be wise if you enter into a contract to add an arbitration clause if you think that a potential dispute will have handle or will touch trade secrets, or maybe the trade secrets will be the core of a procedure. But today we will show you how you can protect your trade secrets in a civil proceeding in Austria, but not only in Austria, because as you can see in the first line of this slide, the protection of trade secrets is regulated in Austria in the Unfair Competition Act, and this Unfair Competition Act implements an EU directive on the protection of trade secrets. So you will have similar rules all over Europe. What I will show you in the next minutes are the general rules, and my colleague Barbara will cover the specific rules, especially that are implemented to protect trade secrets. In Austria, there is in the Austrian Civil Procedure Code, which is 130 years old, there are no specific rules or no specific chapter on trade secrets. And of course, trade secrets are a problem because civil procedures are public, the hearing is public. So in general, you can't protect your trade secret. So the courts have to decide on a case-to-case basis, on a balance of transparency on the one hand and secrecy on the other hand, how to handle trade secrets. In general, and I think this is all over the world the same, each party has to assert and prove all the facts supporting its claim or defense. So maybe you have to rely on a trade secret to support your claim, or also as a defendant your defense. The judge evaluates all the evidence under the principle of free judicial assessment, freie Beweiswürdigung, as we call it in German, which is one of the core principles of our judicial system. And as I said before, court hearings are public unless confidentially or other exceptional grounds justify the exclusion of the public. And especially in civil proceedings, this happens very, very rarely. In criminal proceedings, it's a little bit different. But in civil proceedings, it's happens very, very rarely. Maybe because under normal circumstances, no one will attend a hearing of a civil procedure case, except maybe a competitor. Then the need to exclude the public may arise. But if the public is not excluded, each party may use the minutes of hearings also for whatever they want to use it. So they may publish these minutes or use it otherwise. So may I have the next slide, please? The first measure in our civil procedure code, which might be a danger for your trade secrets, is the right to question the opposing party. This is not the right to question the managing director in a situation like a witness. I will handle that afterwards. It is the right from one party to the other party to answer questions related to the dispute, and with these questions, you can also answer the other party. Is there evidence? Do you have this or that document? which witness could know this or that with respect to the dispute. And the other party is in general obliged to answer the question. If the other party doesn't answer the question, then the judge may or not may, the judge is then free in his judicial assessment to evaluate what this means if a party doesn't answer a question. So this is quite a strong tool. And the next one is the submission of documents. It's even stronger because a party may request the production of specifically identified documents if you know that it is in the possession of your opponent. So you might ask him to provide, you are entitled to ask the other party to provide documents in general. And one thing which is also quite important in this is that in Austria we don't have a fruit of the poisonous tree doctrine. So also unlawful obtained evidence is admissible. I would say the most important example is that people record phone calls, which is in general illegal here in Austria, and then a witness is examined about this phone call, and afterwards you can hear his voice on the phone, and in the phone call went completely different than that what he has told the judge before as a witness, which is of course then a false testimony and a criminal offense. And the next evidence that may lead to problems with respect to trade secrets is the interrogation and witness testimony. Witnesses, I think this is all the same, have to appear before court and give a full and truthful statement. As said before, a false testimony is a criminal offense. And besides that, also parties. So if a natural person, a human being is claimant or a defendant, then this is the party. If it is a company, then the managing director would be interrogated. He or she has also to show up before court and might be interrogated, but they cannot be physically compelled. But once again, if a party doesn't show up at court, this is also a strong sign to the judge that this party might not be interested in winning the case. Maybe we can go, I told you before that you might ask the counterparty to produce a document, and then the counterparty is obliged to produce this document at court. But each party may redact documents. In general, you have to produce the whole document. But if the document is a lengthy one, it might happen that sections of this document do not relate to the dispute, and therefore these parts may be redacted. So you black it, and so the other party cannot read these parts of the document, but you have to show this document in an unredacted version to the judge, so that the judge can decide whether the redacted parts are part of the dispute or not. Then you can, and now we come to the protection of confidential information in civil proceedings. In general, as said before, you are obliged to produce a document if the other party asks for it, but if it would infringe a trade secret, then you may refuse the disclosure of the document, and the court has to decide about it. The same applies to a witness. A witness might refuse answering specific questions, but only specific questions if they are related to a trade secret. And the court may exclude the public from hearings. As said before, with respect to the hearing, the practical effect is relatively low, but because normally no one shows up at a public hearing in civil procedures here in Austria, but if the public is excluded from the hearing, then you are also not allowed to publish the minutes of the hearing, which otherwise might happen. Thanks. Barbara, please.
Hello, good morning, also from my side. Thank you, Thomas. So all the principles Thomas has explained apply to patent and life sciences proceedings, and one has to keep these principles in mind. So we just quickly look at trade secret proceedings. So far in Austria, these rules have only been applicable if the whole proceedings are dealing with trade secrets. So they would not apply if you, for example, have a, I don't know, process on pharmaceutical litigation and not under the Unfair Competition Act, but under the Patent Act. But of course, there are many voices in literature who claim that these principles should apply, at least by analogy, also to patent infringement proceedings and life sciences proceedings. Why would they be relevant? Because the burden of proof for the plaintiff is reduced, because in the claim, the owner who claims to have a trade secret infringed must initially only disclose the trade secret or the information to the extent necessary. For example, if you say a formula was stolen, then you would not have to describe the formula itself, but you would have to describe the circumstances. You would have to also explain the existence of a trade secret and try to limit the disclosure as far as possible. And the judge then can take appropriate steps during the proceedings. For example, what is explicitly foreseen, that the trade secret is only shown to an expert, and the expert then provides the judge with an opinion where the trade secrets are redacted. So this, for example, would be an interesting option also in life sciences and patent infringement proceedings. And these, even if during the proceedings trade secrets are disclosed, then the judge can oblige all the parties and everyone involved to keep the confidentiality obligation after the proceedings, and specifically instruct the parties. Please, the next slide. What is really interesting is that the Patent Act, under which proceedings under life sciences and patent infringements are, which provides the main provisions, there is no explicit confidentiality rules for the infringement proceedings. Only there's one rule, 119 Patent Act for nullity proceedings, which you have before the patent office, but no rule on infringement proceedings. So in actually litigants have to rely on the Civil Procedural Act described by Thomas, which has scattered provisions, and or try to bring the rules of the Unfair Competition Act at least analogously into the proceedings. Of course, it's a very difficult balance between transparency, fair trial, and secrecy, which is particularly different. There is one important rule which shifts the burden of proof to the defendant in those proceedings where we are talking about a process patent. So where a product, which very often happens, and we had this case in the past, you have a pharmaceutical product which is produced by a specific patent protected proceeding, and you find a competitor offering the same substance on the market, and you are sure this can only have been produced in the same way, but of course you have no way to look into the process, the manufacture process. So in this case, the plaintiff has to evidence that the competitor has a new product on the market, and this product has the same composition of the contested product, of the protected product by the patent. Then the defendant, of course, will challenge first, this is not the same product, it's not the same substance, it's state of the art whatsoever. But if these evidence fails, then the defendant has to evidence that his product was manufactured under a different process, not a patent protected process. So this is a real a very, very important rule for process patents, which at least facilitates the burden of proof for the plaintiff. But of course, then the defendant has the same trade secrets issues we had discussed. So let us take a very short look if the Unified Patent Court Agreement brings some new ideas to protect trade secrets, which might also be used in Austrian proceedings for patent infringements. Actually, there is a specific rule, Article 58, which gives the judge very wide discretion to protect trade secrets. We can already look at the next slide, please. The parties, of course, have to apply for confidentiality measures, and the court has different options to take. This is all specified under Rule 262A. And so far, there was one decision, quite interesting, where the court the local chamber has stated that an attorney eyes only order was granted, so that only the attorneys of the parties could look into a document which concerned confidential financial information in a patent dispute. This is new and not known to Austria. The case law is still developing under the UPC, and the local divisions, of course, differ. As I mentioned, there is at least one natural person rule per party to look into the files, attorneys only access. So the local divisions are also struggling at the moment to balance confidentiality versus access. Therefore, the Court of Appeal is expected to harmonize these approaches over the time. What are now the practical takeaways for litigants in pharma litigation? It is crucial to identify trade secrets early in litigation, of course, and use clear internal confidentiality protocols. Just one note, we had a recent case in Austria where the trade secrets claim was dismissed because a former employee still had access to all information. The company had forgotten to cut the employee off the systems. So this is also critical if litigation is coming up. Be prepared, have internal security measures in place. So Austrian law provides solid substantive rights, but limited procedural tools. We hope that the UPC will introduce a modern and harmonized confidentiality regime to set European standards also for Austria. Thank you very much for your attention.
Yes, thank you very much to Vienna. Thank you very much, Barbara and Thomas. We will now move on and discuss the implications of the new Product Liability Directive on the medtech industry. Dr. Astrid Seehafer is one of my partner colleagues from Luther. She is located in our Berlin office, and her main expertise are product compliance advice and product liability disputes. especially in the medtech and pharma industry. She has already successfully defended a large number of product liability claims in all instances. She regularly publishes articles and commentaries on product liability and gives lectures on new developments and case law in product liability. Today, she will give us some insights into the new product liability directive, which will have a huge impact on litigation risks. Astrid, we're looking forward to hear.
Thank you, Christoph. So in the next section of our webinar, I will provide you with a brief overview on the implication of the new product liability directive on the medtech industry. This new product liability directive has been issued last year, and member states have to implement the new rules into their national laws by the end of next year. So from the next year on, end of next year onwards, we will have a completely new product liability scheme. So to give you a brief intro or overview on the practical implication, we have selected a case study for you. So think of a medical device, for example, a hip implant. Such hip implants, or the performance of such hip implants, mainly depend on the product, of course, but also on the positioning in the body and patient specifics like the weight, age, or other illnesses. The manufacturer of this hip implant is located in the US, and they usually sell their products online. The manufacturer has issued, after having placed the products on the market, a field safety corrective action restricting the indications on male patients for this specific implant. Before that, a female patient was, however, implanted with such a device, and after 11 years in situ, she suffered from an infection and had to undergo a revision surgery. The patient then files a claim against the US manufacturer and says the implant is defective, it has increased wear, and due to this defect, due to this increased wear, I got this infection and had to undergo revision surgery, and therefore she asked for compensation. Such a claim would usually be based on product liability. Product liability is harmonized on EU level since nearly 40 years, and it says that the manufacturer is liable for damage caused by a defect in its product. What is important to note is that it is a strict liability. It means that no fault on the side of the defendant is required. What is required, however, or what is important, is that the claimant has to prove the defect, she has to prove her damage to health, and she has to prove the causation between the two, so between the defect and the damage. And this may, in practical consideration in a concrete dispute, be challenging for the claimant to prove, for example, the defect, while she has, of course, or should have the explants of the device. She usually does not have the manufacturing records, she does not have the product drawings, she does not have the internal records of market surveillance activities. And at least based on most national laws within the EU, she does not have the right to ask the manufacturer to disclose it. And in that context, it may sometimes be difficult to prove a defect, and therefore that the claim could be dismissed. Usually it's, oh, sorry, we have to go back for a second. She can usually prove her damage to health. But what is also challenging is to prove the causation between the defect and the damage. So to say that the defect, the specific defect, caused the specific damage to health, and that there's no other reason for it. Especially, as I said before, there are typical other reasons or implications on the performance of a hip device. So that therefore she would need to exclude that not the positioning was the cause and not any alternative patient-specific factor, for example. Due to that, there's also a risk that the claim could be dismissed. A practical challenge for her, for our patient, would also be that the manufacturer is based in the US, and we do not have in this specific case an economic operator in the EU. So, which is of course possible. You can file a claim against a US company, but in terms of enforcement, there may be challenges. In our specific case, the claim would definitely be dismissed, however, because the damage occurred after 11 years after placing the product on the market, and our strict product liability scheme currently says after 10 years, we have a long stop. That means that all product liability claims expire. And these challenges are also the reason for the new directive for the European legislator. They found that the current product liability directive, which is already 40 years old, since then a lot has changed, of course. On the economic level, we have new technologies, we have online purchases, we have complex and international supply chains, but also on a legal level, our product safety law on the European level has become much more differentiated and much more complex. Therefore, they handed down a new product liability directive, and what will change? Actually, in a nutshell, everything will change. All definitions will change, the whole concept will change, the scope will change, and the proof will change. So I will go into some of those details in a minute relating to our case study, but what is under the line important to note is that most of or almost all changes are to the determinant of the industry, so that the risk, the product liability risk, definitely increase. So starting with a new definition of a product defect, so the heart of product liability, what remains the same. A defect is, or the product is considered to be defective when it does not provide a safety that a person is entitled to expect. So that's a very vague definition, actually. And it says that you have to take all circumstances into account. This also remains the same. But the current law focuses on 3 aspects. In the future, it will be 9 factors. Most of them focus on new technologies and AI. And in this context, also the relevant moment in time, which is decisive for the assessment, may change relating to AI concepts. What you have to take into account, this is also new, is the product safety law and recall specifically. That means in our case, where a recall or safety product as other safety action measure was handed down, this would be considered in the dispute. Although it is important to note that a recall or other safety measure does not automatically imply that a product is considered to be defective. However, a court would look into it and would take it into account in their consideration and assessment. Important or practically different in the future will be in our case that we do not, or our patient would not be forced to file the claim against the manufacturer, but because in the future there will be much more persons who can be liable under product liability law. So in our case, she could, for example, file her claim against the authorized representative. It's more a regulatory role currently for medical devices required under the medical device regulation. They are concerned with regulatory obligations, but in the future they will also be liable under product liability law. The long stop, which I discussed, and it was would be mainly definitely the reason for dismissing our case. This will also change. The general period will remain the same, 10 years, but in specific cases where we have a latency period of damage to health, like, for example, for medical devices, like for medicinal products, it may be prolonged to even 25 years after the product has been placed on the market. 25 years, there's a very long time. After such a long time, most of the people who were in the company at the time when the product was developed are not in the company anymore. Probably don't even have the documentation anymore. So this will change the complete situation for defending a product liability claim. But the main game changer actually is on the side of evidence. We have a new disclosure obligation. That means that companies may in the future be forced to disclose evidence in their possession. For example, manufacturing records, design details, medical surveillance documentation, etc. Something which is currently not possible under the current the product liability regime and the national legislation. There are only very few requirements for such a disclosure obligation. You have to have an application. Okay, that's quite easy to do. The claim must be plausible, and you have to have some evidence for it. And the evidence must be in the possession of the defendant. That's quite easy, and then you can ask for it. There are some restrictions. It has to be necessary and proportionary, and important, even trade secrets may be subject to the disclosure obligations. In that case, court can take special measures to protect them. Let's see what a special measure will look like, but it's important to know this is even possible. If a defendant says, okay, I don't want to disclose my trade secrets or other documentation, it's important to know that in this context, the product defect would be presumed. Therefore, they have to refute this presumption in order to win this dispute. There are also other presumptions, and we have it on the next slide, which will lead to the situation that it's easier for the claimant to prove the claim. The general burden of proof remains with the injured party. However, we have several assumptions, not only in case of breach of disclosure obligations, but a defectiveness would, for example, also be presumed if we have an obvious malfunction. Causation would be presumed if we have a typical defect, whatever that means, or damage is typical for this defect. And both defectiveness and causation can be presumed in complex cases. So complex cases, usually medical devices, medicinal products, food products. In that case, if we have this assumption, the defendant again must then refute this presumption and cannot only lay back and say, okay, defendant, you have to prove it. So overall, you can say we have a completely new product liability scheme. And product liability claims can be enforced relatively easily in terms of evidence law and in the light of especially the new representative actions options, also on a rather large scale, of course. So medtech industry will be faced with higher liability risk. There are certain measures which you can do to precautionary measures to limit those risks, but in the end, you cannot get rid of it. Thank you very much.
Yes, thank you very much, Astrid. That was very interesting and helpful, I think. Our last topic today will be presented by Jean-Baptiste Ranial of the French law firm Fidal. Jean-Baptiste co-heads both the intellectual property, information technology, and life sciences departments at Fidal in Lyon, France, leveraging over 2 decades of specialized experience in these fields. He is providing counsel to a wide array of life sciences companies on both contentious and non-contentious matters, encompassing IP/IT law, health legislation, and regulatory compliance issues. His topic today is pharmaceutical laboratories before administrative courts in France. Jean-Baptiste, the floor is yours.
Thank you, Christoph, and good morning to everyone. So I will now present a brief overview of how administrative litigation initiated by pharmaceutical companies has evolved in France lately. To frame this discussion, let me first provide some regulatory context. So the French lawmakers have tightened regulation of the pharmaceutical sector, aiming in particular to reduce public healthcare expenditures and ease pressure on the social security accounts. And to name but a few, the measures adopted typically include budgetary control mechanism, such as the safeguard clause that I will describe later, and which seems to be quite similar to the payback mechanism presented by Hermano earlier. Another line of measures concerned regular price reductions for reimbursable medicinal products, which are set by the Economic Committee for Healthcare Products, so the CEPS in French. In addition, the legislature has introduced a number of instruments to address shortages of critical or essential medicinal products, such as, for example, mandatory shortage notifications or stockholding obligations for that kind of products. So this regulatory tightening is likely to generate a significant increase in litigation before French administrative courts. And indeed, that's precisely what we are already observing today. So next slide, please. So as you can see, the most recent data from the French National Agency for Medicines and Health Products Safety, the ANSM in French, show an enforcement intensification. Between 2023 and last year, we witnessed a 71% increase in new claims filed against the ANSM, rising from 45 to 77 cases. This could signal a fundamental shift in how the pharmaceutical companies or industry actors are responding to regulatory decisions from the ANSM. Companies are increasingly willing to challenge the agency in court in light of this data. Correspondingly, judicial activity has accelerated. As you can see, administrative courts rendered 46 decisions last year compared to 31 in 2023, which is a 48% increase. Now, here's what's particularly not worthy, I would say. It's that despite this litigation wave, ANSM maintains a significant success rate. As you can see, in both years, 93% of disputes were resolved in the agency's favor. So this consistent judicial validation demonstrates that the agency's decision, while they are frequently contested, are generally considered legally sound by the administrative judge. However, and this is crucial, the financial stakes have exploded. The number of sanctions imposed by the agency increased sixfold, from 6 to 36. And more dramatically, the total monetary value of these sanctions skyrocketed from approximately €500,000 to over 8 million euros. So I'm sorry, but you are showing you on the CEPS. No, that's the previous slide again. I was still on the ANSM data. Sorry, but the previous one, please. ANSM, yes. Thank you very much. So okay, what explain this escalation? We are likely seeing a convergence of factors, more assertive sanctioning policy by the ANSM, and an actual increase in compliance breaches, which I have to say are all related to medicinal products stock shortages. And a regulatory environment where penalties are being deployed more systematically by the agency as a deterrent mechanism. So for pharmaceutical companies, this translates into elevated exposure, both in terms of potential sanctions and the necessity of robust administrative defense strategies. This enforcement trend operates in parallel with another critical litigation front, which is pricing disputes. So next slide, please. Yes, the statistics are that you can see. They concern the decision from the CEPS, so that's the economic committee, as I said earlier. The statistics are unambiguous. Between 2022 and 2023, contentious appeals against CEPS doubled from about 10 to 20 cases annually. Pending litigation figures mirror this trend, jumping from 13 new claims in 2022 to 25 in 2023. But here's what's most significant. In 2023, over half of all new claims specifically targeted the safeguard clause mechanism, so that I will expose later. This concentration signals that pharmaceutical company would say frustrated by this particular regulatory instrument and its huge financial consequences. So now let's discuss judicial outcomes, because the trajectory is quite revealing. In 2022, approximately half of the 14 administrative rulings resulted in annulments of the CEPS decisions. A substantial success rate for pharmaceutical companies. However, as you can see, in 2023, despite the volume of rulings increasing to 21, only 4, that's about 19%, resulted in annulments or confirmations of annulment. Regardless of causation, the pattern is quite clear. While litigation volume is rising, the probability of successfully overturning a CEPS decision has diminished. This doesn't mean that challenges are futile, far from it, but it does mean that legal strategies must be increasingly sophisticated and precisely targeted. However, we believe that the chances of success may increase, and they already may have increased during this year, 2025, but they may also increase in the future in light of our own experience and in light of the litigation which is currently pending before the administrative courts. Which brings me to the most contentious pricing mechanism of all, the safeguard clause. So next slide, please. So it's a complex mechanism, but I'll try to briefly explain it. So every company involved in the exploitation, parallel importation, or parallel distribution of reimbursable medicinal products is potentially liable for this contribution or kind of tax. It's triggered when the aggregate national turnover for reimbursable products, reimbursable medicinal products, net of certain rebates, exceeds a ceiling designated at the amount M, which is established annually through the Social Security Financing Act to ensure compliance with the national health expenditure target called ONDAM in French. When this threshold is breached, a progressive rate applies to the excess, and the resulting financial burden is then distributed among companies proportionally based on their respective turnover and growth. So the critical evolution of this mechanism is that this safeguard clause has been triggered almost every year since 2014. And what was originally conceived as a genuine safeguard, a safety net for unexpected expenditure spikes, has become a systematic revenue extraction tool. It's no longer exceptional, it's structural. So unsurprisingly, this has generated extensive litigation, and companies challenge what they perceive now as a disguised retroactive tax that distorts market dynamics. So our law firm, Fidal, has been at the forefront of this litigation. We were amongst the first law firm to challenge these clawbacks, and we've secured significant victories, including recent decision ordering from administrative courts, ordering the cancellation of CEPS decision on the M clawback, so the contribution M for the year 2021, and we obtained reimbursements of the sums paid in this respect by the pharmaceutical companies. So our approach combines substantive challenges, questioning the legal foundation and calculation methodology of this clawback mechanism, with procedural strategies designed to exploit vulnerabilities in the administrative process. These avenues remain active and continue to yield results for our clients. Thank you for your attention, and I'm happy to take any questions you may have.
Yeah, many thanks, Jean-Baptiste, also for your contribution. Ladies and gentlemen, it is already 11:10 now. We have reached the end of our today's webinar. We thank you all very much for your attention, and we hope that we have given you at least some valuable thoughts and ideas for your practice. In case you have any questions, please give us a call or drop us an email. Of course, all participants of this webinar will receive the presentations within the next days. So we hope to see you again at our next webinar. Have a good day and bye-bye. Thank you.